For the record, then, this is cause number CCL 21C018 in the interest of Danny Ray Lynn Burrow, a child. And Mr. Doherty, is the petitioner ready?
The petitioner's ready, Your Honor.
The court takes a note of the file and the documents filed therein. They indicate that both respondents have been personally served with citation. You get to that right quick. And it appears that the respondent, Patricia, is that Boyd, B-O-Y-T-E?
Yes, sir.
Yes, sir.
Was personally served with citation on March 1st, 2021. There is no answer on file in her behalf, nor does she appear regarding this Zoom hearing. In addition, there is on file with the court a citation for personal service served on Andre Glenn Burrow. That citation was personally served on February the 11th, 2021. Each return of service has been on file with the court more than 10 days, exclusive of the date of filing and of this date. The respondent, Burrow, also does not appear by way of Zoom or otherwise. It therefore appears to the court that both respondents are in default. And Mr. Doherty, you may call your first witness.
We call Gina Petramo.
Ms. Petramo, will you hold up your hand and be sworn, please? Do you solemnly swear or affirm the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may lower your hand, and Mr. Doherty, you may proceed with your testimony.
Thank you, Your Honor. We're here on behalf of Danny Ray Lynn Burrow, who you are the paternal grandmother of this child. Is that correct?
Correct.
Okay. Now, Danny was born May 31st in 2018 in Mississippi to Patricia Leanne Boyd, who is your daughter, and Andre Glenn Burrow, who is at least a presumed father of the child. Is that right?
Correct.
Okay. And at the time of birth and for a period of time thereafter, both Patricia and Andre and the child all resided together in Mississippi. And during that time, the father, Andre Glenn Burrow, has represented to others that he was in fact the father. Is that right?
Correct.
Okay. Now, we've checked into knowledge on all this. There is no court that has continuing jurisdiction of the child, and nothing has ever been filed in court regarding the child, either in Texas or Mississippi. Is that right?
That's right.
Okay. Now, at some point in time, tell the court about the Mississippi Child Support Services got involved with the child, and there was some agreements made between apparently the parties, the mother and the child in Mississippi. Is that right? Is that your understanding?
Yes.
And pursuant to those agreements, the mother was not supposed to be having the child in her custody alone at any time. Is that right?
Yes.
And tell the court how the child came to Texas and to live with you.
The father works in the oil field. The case was opened in August of 2019 against Patricia Boyd. And since the father worked in the oil field, a family friend was awarded temporary guardianship. And when he also had supervised visit. When I went to Mississippi to see if the baby could come back to Texas, the caseworkers told me that she could come back to Texas if I brought the mother, Patricia, with me, and if the father agreed to it. So the father agreed to it, and he went on his way to work. Coming through Texas, he would bring the child to me and to the mother, and on his way back, he would pick the baby up and take her back to Mississippi to stay with him for 10 days to 2 weeks. And that lasted, she came to Texas in October of 2019, and the father brought her back and forth twice in a 2-month period, and then he stopped picking her up, and she has remained with me since that time.
So in October 2019, just to clarify, both the mother, your daughter, and your granddaughter came to live with you. Is that correct?
That's correct.
Now, at some point in time, CPS in Texas got involved. Is that right?
Yes, sir.
You
December
recall?
of 2020.
December of 2020. And pursuant to the Texas CPS, even though no court filings have been done, there was a child safety plan that was agreed to that gave you the temporary possession of the child. Is that right?
That's right.
And do you know when that went into effect?
December of 2020.
December 2020. And so ever since that point in time, you had the primary possession of the child, and Patricia lived with you up until just recently. Is that right?
That's right. Up until January of 2021.
And so after the filing of this particular action, Patricia later has removed herself from your residence to establish her own, and we had to have her served. Is that correct?
That's correct.
Okay. Now, pursuant to the agreement of CPS, at least for the visitation with Patricia, was to be a supervised visitation. Is that right?
That's right.
Okay. And the visitation for the father, Andre Glenn Burrell, what was that agreed to be?
It was agreed to be, he agreed with CPS pending passing drug tests that he would also agree to supervise visit.
Okay. Has the father visited with the child since that time?
No.
Actually, what we're filing here is a not only petition and suit affecting the parent-child relationship, you're asking the court to also establish that Andre Glenn Burrow is the father of the child. Is that right?
Yes, sir.
Mr. Burrow, my understanding, has been by agreement with you paying some child support directly to you each month in the amount of $600 per month. Is that correct?
Yes, sir.
And when did he start doing that?
August of 2020.
And except for maybe the present month, he has continued to make those payments. Is that right?
Yes, sir.
Okay. Not court-ordered payments, but just an agreement between the parties.
Yes, sir.
Okay. And pursuant to y'all's just verbal agreement, you, through your husband, have placed the child on y'all's health care plan. Is that correct?
That's correct.
And the agreement with Dad was that if he paid the $600 a month, that y'all would maintain the health care and pay any health care benefits and any uninsured medicals that might arise. Is that right?
That's correct.
Now, I want to back up because the child at birth was diagnosed as having Turner syndrome. Is that right?
That's correct.
And my understanding, just for a quick short analysis, Turner syndrome is a genetic defect that only occurs in girls, occurs less than about 200,000 times a year in the United States. Is that your understanding?
Yes, sir.
And pursuant to Turner syndrome being a genetic situation, some of the long-term effects of that are like stunted growth and later onset puberty and possibility of heart problems. So when a child at a very early age is diagnosed with this, there needs to be a healthcare plan devised and carried out long term. Is that right?
That's correct.
Have you had the child under such plan?
Yes, I do.
Just give a kind of a short scenario of what's been done and what we anticipate is going to need to be done for this child.
She sees a cardiologist, an endocrinologist, and a pediatric orthopedist once a year, unless there's findings that she needs more care. Between the ages of 4 and 5, she'll need to start growth hormones, and between the ages of 10 and 12, she'll have to start estrogen therapy so that she'll develop into puberty. She's prone to learning disabilities also.
And so based on, without getting into too much detail about prior history between mom and dad on this, it's your understanding and your allegations that the child would be better off with you, not only better off with you, but that certainly that mom is incapable of maintaining the appropriate care for this child. Is that correct?
That's correct.
So you're asking the court that you be appointed the managing conservator of this child and that the parents each be a possessory conservator. Is that right?
Yes, sir.
Okay. Now, you're asking the court, since dad has been paying $600 a month, you would just like the court order to reflect that into the future. Is that right?
Yes, sir.
As far as mom is concerned, she has moved out of the house of your residence in her own residence. Not for sure if she's employed or not, and we would ask that child support be mandated for the mother pursuant to the presumption that she's working 40 hours a week at minimum wage. Is that right?
Yes, sir.
Is there any other children that Patricia Boyd has an obligation to support?
No.
Is there any other child that you're aware of that Andre Glenborough has an obligation for support?
He has a child in Houston, and the child support for that child is automatically drafted out of his account, his paycheck.
So your understanding is he has one other child other than Danny. Is that right?
That's correct.
But
She's 9.
based on what performance the dad has been doing, you're requesting, we don't have any information showing his income, but based on his performance that he has agreed and been following through, at paying $600 a month, then you feel like that is reasonable and in the best interest of the child. Is that right?
Yes, sir.
Now, as far as visitation is concerned, um, you've expressed to me that as long as Patricia and Andre are not together, then Andre's parenting skills appears to you to be fairly okay. Is that right?
Yes, sir.
He does have residence in Mississippi where he has close family members that live in proximity around his residence. Is that right?
Yes, sir.
And so he does work in the oil field, and he historically works in West Texas. And right now, I think he's working in New Mexico. Is that correct?
Yes, sir.
And he travels back and forth. He works about 2 weeks on and usually off about 2 weeks. Is that right?
That's right.
So, based on his family and other things that might assist with there, we've just kind of discussed that maybe allowing him a visitation, maybe one time a month for up to 6 days while he is off, that you would be approving of that. Is that right?
Yes, sir.
You would, I think we discussed, however, that your concerns are that when he drives back and forth from like New Mexico to Mississippi, he usually gets off from work, drives straight through, and he's on the road for a long period of time and probably sleep deprived. Is that your understanding?
Yes.
So probably what we would request the court to enter some sort of order that on this one time a month, this 6 days, maybe to do the exchange at 10 a.m. in the mornings, that Dad would pick up and deliver to your residence, but that he give you a prior notice of visitation requesting it at least 48 hours in advance. Is that right?
Yes.
And that also that his visitation period that would be approved on a case-by-case basis with you at that request, that he also be off the job for 48 hours to make sure that to hopefully enable that Dad would not be sleep deprived when having this toddler in his possession and traveling back and forth to Mississippi. Is that what you're asking the court to do?
Yes.
Okay. As far as visitation with Mom, Mom has been having some regular visitation with the child at your house several days a week for a few hours at a time, supervised by you. Is that correct?
Yes, sir.
And you're willing and desirous that Mother have some visitation, but that visitation be supervised either by you or by your husband, Norman Petrimo, and that we set up maybe a visitation on Tuesdays and Thursdays from 4 p.m. to 8 p.m. Is that right?
Yes, sir.
However, that you would want Brianna to also, or Patricia is her first name, to also, were you wanting her to give you a prior request for that, or just that she have it available for every Tuesday, Thursday?
Just have it available every Tuesday and Thursday, but not to interfere with the dad's visitation.
So probably would be best to have like a 24-hour notice from her to you to even exercise those visitations, because in the order we would propose that any of these Tuesday, Thursday visits that might be a conflict with dad's once a month, 6 days, that those would just not be allowed. Is that right?
That's right.
Okay. You feel like that all of the things we're asking the court here today is in the best interest of this child?
Yes, I do.
Okay. Ms. Petrimo, is there anything else that we've discussed that I have failed to bring up today that you recall that you'd like to tell the judge?
No, sir, I think you covered it.
We rest, Your Honor.
Ms. Petrimo, where do you live?
Atlanta, Texas,
Okay, can you give me a specific address?
73 County Road, 1148, Atlanta, Texas, 75551,
How long have you lived at that?
2017.
As I understand it, this child came to live with you along with the child's mother in October of 2019. Is that correct?
That's correct.
And has the child resided with you continuously for a continuous period of time for at least 6 months prior to instituting this action?
Yes, sir.
Okay. You mentioned that, did I understand that Mississippi got involved in the way of asking for child support from Mr. Burroughs? Is that correct?
No, sir. The child support is an agreement between him and I.
Okay. There's not been a formal action. By formal action, I mean a lawsuit of some type filed by, for example, the Attorney General's office or anyone else ordering him to pay child support up to this point. Is that correct?
That's correct.
There also haven't been any, as far as you know, any other court that's entered any orders regarding conservatorship or support of this child. Is that correct?
That's correct.
Okay. All right. Can you tell me just briefly, without going into a tremendous amount of detail, what led to your daughter and the child coming to live with you in 2019 and why the child has remained with you?
The CPS case in Mississippi against my daughter, the child was awarded a family friend guardianship. And that lasted for about 6 weeks, and then she could no longer do it. And the father worked in the oil field and he could not keep the baby full time. So I requested of CPS that the child and the mother come and stay with me, and that the father could pick her back up on his way back to Mississippi because he travels Interstate 20 back and forth to work. And the CPS said that they would agree to that as long as the father agreed to that, and he did agree to that. And so that's how she came to stay with me. And he picked her for 2 months. He picked her up and took her back to Mississippi, and then he stopped doing that, and she just continued to stay with me. He stopped coming and picking her up in December of 2019.
Why was CPS involved in?
My daughter's drug use.
Okay.
She had the baby. She had the baby with her, and there was an altercation, and the baby got maced and cut with some glass.
Okay. But the primary underlying problem is your daughter uses illegal drugs. Is that correct?
That's correct.
Okay. What about Mr. Burroughs? Does he use illegal drugs as far as you know?
He used to in the past, but he's been passing his drug test through the CPS here in Texas. And I knew he had a history of drug use in 2019, but he's passed his test since then.
When you say CPS, as far as you know, there's not a case filed by CPS. This is just an informal agreement. Is that correct?
Say that again?
CPS has not brought a lawsuit asking for custody of the child, as far as you know. Is that correct?
That's correct.
Okay. All right. Anything else, Mr. Doherty?
I think, yes, sir, Ms. Petrimo, we would probably want to add something in an order that, well, let me back up and ask it this way. There has been, even since in Texas, there has been sometimes in some altercations between your daughter and Andre. Is that right?
Yes.
They got into a fight in your front yard. When was that?
That was in the last time he was here, which was in August of 2020, a physical fist fight.
So as I've understood it from you, that there seems to be some problems if the child and your Andre and Patricia are all together. And so even in times that the dad would have possession of the child for visitation, you would want, or we would request that there be like a permanent injunction that the dad is not supposed to visit with the mom while he has the child with him.
Yes, absolutely.
And you feel like that if that were honored, then the child would not be at risk of being with the dad.
Yes, I agree.
Okay. That's all the follow up here.
All right. All right, then the court does find that it's in the best interest of the child to appoint a person who is not a natural parent of the child. Court finds in that regard that to appoint one of the parents under the circumstances could be harmful and detrimental to either physical or mental safety and well-being of the child. Therefore, the petitioner, Petrimo, is appointed as primary managing conservator of the child. The respondents are appointed possessory conservators with all the rights, duties, and responsibilities of possessory conservators. Regarding child support, I will order that the request for child support by each respondent be granted based on the evidence that the father of the child is currently paying child support in the amount of $600 per month. I will continue that requirement. First payment will be due May 1, like payment monthly thereafter until further order of the court or until the child is emancipated. I will base the mother's child support on minimum wage. So I will order her to pay $223 per month. First payment due and payable on the first day of May. The like payment thereafter under the same circumstances as Mr. Burrow. Regarding visitation and access by each parent, I'll simply adopt the requested visitation and access provisions. I won't try to go back through all of those provisions that petitioner is asking for. It's all in the record. If that arrangement appears to be in the child's best interest, I will include in that a permanent injunction against both parties that neither party be with the other party whenever that a party has possession or access of the child. Of course, I am granting the request to legally adjudicate Mr. Burroughs, the respondent, as the natural father of the child. Anything else that I've left out?
I believe you covered it all, Your Honor.
All right. Then, Mr. Doherty, if you'll prepare a conforming order, then I will sign that when I receive it.
Yes, sir, I sure will, Your Honor. Appreciate it. May we be dismissed?
Yes, sir.